Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Paralegals are often the backbone of immigration law, and in 2025, their role is evolving fast. My friends at e-Immigration asked the experts what sets great paralegals apart in 2025. From ethics to tech savviness, these are the top 5 skills that help paralegals go from good to great. Head to get.eimmigration.com/resources to read more, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Welcome to a monster week of 9 cases on the Immigration Review Podcast. Before we get started, first off, congratulations to friend of the podcast, Eric Lee, for starting his new law firm with Chris Godshall Bennett, Lee and Godshall Bennett, LLP. According to Eric and Chris, they'll be focusing on impact litigation, but of course, not solely impact litigation, also visa denials, civil rights litigation, and other things. Congrats, guys. Wishing you all the best. Additionally, this came across my desk, and I think it'll be helpful to the immigration bar, so here we go. Researchers at Fordham University and City University of New York are developing guidelines for psychological evaluations used in immigration cases, and they want to hear from immigration attorneys and DOJ EOIR representatives. They have a survey asking about what you find helpful and unhelpful in these evaluations, what's in the evaluations, the process of requesting them, how useful they are in supporting cases, everything. The survey is confidential and takes about 25 minutes to finish. Those who finish the survey are entered into a drawing for 10 MacBook Airs, 10 iPads, and 100 $100 gift certificates. That's 125 chances to get something in addition to contributing to the guidelines, of course. And a partridge in a pear tree. I'll put the link to the survey in the show notes. You can also visit the research project on LinkedIn at Psychological Evaluations in Immigration Law. Please take the survey. Check out the show notes for the link. Now, without further ado, 9 cases. First up is Hernandez, Guardado v. Bondi, published by the 4th Circuit on August 5th, 2025. This case is about asylum. Miss Guardado, as the 4th Circuit calls her, quote, fled El Salvador because she was forced into an abusive relationship with a gang member named Juan, end quote. He was a gang member and he threatened to do a lot of bad things. And he beat her and threatened to murder her if she went to the police. She fled to her sister's home in San Salvador, but fled to the United States after 2 months when she learned that Juan was looking for her to kill her. The threats continued while she was in America. Quote, in December 2016, roughly 2 years after Miss Guardado left El Salvador, her father was shot and killed in Cabanas. Miss Guardado suspects that Juan's gang killed her father because her family never received threats from anyone else, end quote. In removal proceedings, which she was permitted to do not from immigration prison, Miss Guardado based her claim on 2 purported particular social groups. 1, Salvadoran women who are continually sexually abused and tortured by gang members, resulting in severe psychological abuse and death to an immediate family member and lack protection from government and police. and 2, rural Salvadoran women targeted by gangs because of a lack of standing. A mouthful, I will admit. An immigration judge didn't believe that those were valid particular social groups, and the BIA affirmed. Plus, reasoned the agency. It's been a while since Ms. Guardado was in El Salvador and all of these things happened. Seems like a lot of this was litigated when Attorney General Sessions' matter of AB decision was good law, because Ms. Guardado moved to reopen once Attorney General Garland vacated that decision, but did not promulgate regulations as he promised, and Ms. Guardado moved to reopen, saying that the BIA should now apply matter of ARCG. The BIA denied that motion. On petition for review, only the first particular social group was litigated. And you know what? The Fourth Circuit remanded. See, the IJ and the BIA rejected the particular social group, in part at least, based on a belief that the group was, quote, impermissibly defined in a circular fashion by the harm to its constituent members, end quote. And I mean, that is true, the group is a bit circular. But says the Fourth Circuit, quote, we join a growing consensus of our sister circuits in recognizing that the BIA cannot simply claim circularity in a perfunctory manner, end quote. The Fourth Circuit cites the 6th, 7th, D.C. Circuit, 9th Circuits, 3rd Circuit, and 1st Circuit for that holding, referencing many a case cited on the pod. True, a particular social group can't be defined, quote, exclusively by the harm its members face, end quote, but that's not necessarily what Ms. Guardado's group did here. More importantly, the Fourth Circuit, the BIA can't just, quote, make a conclusory judgment that a particular social group is circular per se, end quote, without getting into the meat of it. Sound like a BIA dismissal that you've received recently? The agency must, quote, determine what underlying characteristics account for the fear and vulnerability of the group and whether the society views those characteristics as distinct, end quote. In so holding, the panel distinguished its holding in Del Carmen Amaya de Seracon v. Barr, episode 27, which, to be honest, does seem pretty on point, but don't let oil cite to it anymore in light of this decision and the powerful footnote distinguishing it for pretty much all cases. The agency needs to provide analysis because, quote, whether a group exists independently of the harm alleged is not always so apparent, end quote. End quote depends on the facts of the particular case, end quote. Most importantly to me, and like so many other circuits and even the BIA at one point, quote, we see no logic or reason behind the assertion that abuse cannot do double duty, both helping to define the group and providing the basis for a finding of persecution, end quote. As the BIA itself said in matter of MEVG, quote, persecution itself may be the catalyst that causes a society to distinguish a group in a meaningful way and consider it distinct, end quote. Tighten up, attorney advisors. Heck, the particular social group likely remains viable even if it is defined largely by persecution because, quote, a group that exists independent of persecution is simply a group that shares an immutable characteristic other than the persecution it suffers, end quote. Emphasis by the court. Oh, by the way, quote, here Ms. Guardado's gender is potentially one such characteristic, end quote. You listening, BIA members and matter of KESG panel, or more importantly, Fourth Circuit practitioners? All of it is a problem here as the BIA did not, quote, reference a single fact relating to Ms. Guardado or the conditions in El Salvador, end quote. Explaining all the things the BIA must and maybe need not do on remand, the Fourth Circuit sent it back. Meaning congratulations, Eric Hans Kirkman for petitioner. Some notes. In a footnote, the Fourth Circuit states, quote, at times this opinion relies on federal case law that cites BIA precedent. In doing so, we recognize that, although Loper Bright declared legal interpretation of the province and duty of the Judicial Department, Loper Bright doesn't wipe away the results of our prior decisions deferring to the BIA's reasonable interpretation of the law, end quote. Sigh. Nevertheless, congratulations, Ms. Guardado. And a pretty interesting observation to throw out there might give the BIA pause about denying again based on its recent onslaught of precedent. They are certainly going forward, they are due no deference. Whatever validity the Fourth Circuit's old deference cases has, it owes none to the BIA's 2025 decisions that I keep talking about on the podcast. Or at least, very low deference. And that is Hernandez Guardado v. Bondi. It's another week, so we got multiple from the Board of Immigration Appeals. First one, matter of Akhmedov, published by the BIA. Guys, you're never going to believe it. It is a BIA decision that used to be non-precedential that the Attorney General has made precedential about not releasing non-citizens. Stop the presses. Seriously, BIA, stop the presses. This is getting ridiculous, and I am but one man. $15,000 bond granted to Mr. Akhmedov. Not chump change, guys. And he has no criminal history. None. In any criminal court, this guy's probably getting bond. But the Department of Justice has made up rules not listed in the statute whereby non-citizens bear the burden to establish that they're not a flight risk when the government chooses to take away their liberty. Here, quote, while we acknowledge the immigration judge's broad discretion in deciding whether or not to release a non-citizen on bond, we agree with DHS that the respondent did not meet his burden of proof to demonstrate that he is not a flight risk, end quote. Mr. Akhmedov is from Russia and claimed he had a permanent address in Michigan with his brother-in-law. Apparently, also the record shows that he has ties to New York, where he's lived. Apparently, the Michigan address is recent. God forbid. The record also shows that a cousin who purportedly resides in Rego Park, New York, submitted a letter saying he'd house Mr. Akhmedov, and the respondent himself moved to change venue from Michigan to New York in 2023. God forbid. And when Mr. Akhmedov was encountered in Michigan in 2025, his record on file still reflected a New York address. God forbid. Only upon apprehension did Mr. Akhmedov file an EOIR 33 reflecting a Michigan address. Call the FBI. Seems like Mr. Akhmedov is moving around a bit, including within Michigan, or he's messing up his forms. Or, literally worst case scenario, he's being a bit sloppy about updating EOIR about his addresses. Honestly, it seems like the BIA is just annoyed that it took him a year to file an EOIR 33. Which I get, but it is a wild reason to take away someone's liberty when granted bond. An even wilder reason to overturn an immigration judge's bond decision. Quote, the immigration judge did not address the address discrepancies, the respondent's length of residence in the country is short, and the merits of any claims to relief from removal are unknown, end quote. But just put an ankle monitor on the dude, right? Unless the real concern is private prison fees? One is left to guess. There is literally no other analysis, yet the BIA concludes that, quote, no monetary bond, even if coupled with alternatives to detention, would be sufficient to ensure the respondent's appearance at future immigration hearings and, if necessary, his surrender for removal from this country, end quote. Pretty astonishing decision in the land of the free, to me at least. But who knows? Maybe I missed an important detail. And that is matter of Akhmedov. Next up is matter of Garcia Martinez, published by the BIA. This case is about waiving fees. The BIA made it more difficult. Mr. Garcia Martinez is from Mexico and hired an attorney from the private bar to represent him in his removal proceedings, as is his statutory right. He did not succeed on a non-LPR cancellation of removal application before the IJ and then the BIA, and had an untimely motion to reopen denied despite having an approved immigrant visa petition filed by a U.S. citizen spouse. Then he moved the BIA to reconsider its denial of his motion to reopen. With that motion to reconsider, Mr. Garcia Martinez submitted a Form EOIR 26A, seeking to waive the filing fee for that motion. At the time, the fee wasn't that much. Now, of course, it's like $1,000. Naturally, this decision does not mention this point, but will surely apply to future filing fee waiver requests as well. Fees are permitted in many courts, and in immigration court too, explains the BIA. And although fee waivers are permitted by regulation, quote, fee waivers are the exception and should not be granted as a matter of routine, end quote. Here in his form, Mr. Garcia Martinez claimed that he had zero income and zero assets and zero of other things. The BIA doesn't seem to believe him because he has a private bar attorney who, I can only imagine, didn't check the pro bono box in his EOIR 27, although this decision doesn't mention that issue or that possibility. The problem is evidentiary to the BIA. Despite saying he had no income, quote, no additional information or documentation was provided explaining how the respondent, who was not detained, could provide basic necessities for himself, including food and clothing, and pay for the services of an attorney for many years, despite claiming to have no income, end quote. Now, getting all of that proof would take time and money for an attorney to compile, so really this decision, to me, seems to be putting an increased burden on nonprofit attorneys. Quote, a respondent's ability to pay the legal fees of an attorney to represent him or her in removal proceedings is evidence that the respondent can afford to pay the fees associated with litigation, end quote. Now, don't get me wrong, with that quote and other quotes from this decision, it shouldn't apply to nonprofit attorney representation, but I don't see how nonprofit attorneys can roll the dice and not make a robust or robustier submission now about the assets and ability of their client, given some of the other language and burdens used in this decision. Quote, to warrant a fee waiver, a non-citizen will need to explain how he or she is able to pay legal fees but cannot pay a filing fee, end quote. Going even farther, the BIA, quote, further concludes that a fee request from a non-detained adult non-citizen that contains zeros in all income blocks is presumptively invalid, end quote. Definitely need evidence for saying you have no income, no assets, and nothing for nothing, explains the BIA. For all of this, BIA relies on some old unpublished circuit decisions out of the 9th and 5th circuits. Suspect here, quote, the respondent has been in the United States for over 24 years, has sought and continues to seek discretionary relief based in part on the support he provides to his United States citizen spouse and 2 United States citizen children, and has retained private counsel to represent him before the immigration judge and the board since 2018, end quote. So how can he have zero money, queries the BIA. Per regulations, the BIA gave Mr. Garcia Martinez 15 days to pay the fee or demonstrate further his inability to pay and eligibility for a waiver. The BIA does not specify whether the new fees or the old fees apply to his refiling, which I'm sure would be very helpful for Mr. Garcia and those reading this precedential decision seeking guidance. In fact, the BIA seems to expressly punt on the issue in a footnote, which puts Mr. Garcia's attorney in quite the bind, I would think. And well, as an untimely motion to reconsider the denial of an untimely motion to reopen, things were looking a bit bleak and expensive for Mr. Garcia. And that is matter of Garcia Martinez. Let's get through 2 heady ones from the Second Circuit before we take a break. First, Garcia Pinach v. Bondi, published by the Second Circuit on August 4th, 2025. This case is about the aggravated felony sexual abuse of a minor provision. So skip it if you'd rather not hear about such things. It's a complicated immigration decision. Let's go. Mr. Garcia is a lawful permanent resident from the Dominican Republic. He's been in LPR since 1981 when he was 17 years old. Should have naturalized a while ago because he was then convicted of sexual abuse in the 2nd degree under New York Penal Law Section 130.62, which involves sexual conduct with a victim younger than 14 years old, albeit a misdemeanor though. An IJ and then the BIA determined that this made him removable because it was an aggravated felony sexual abuse of a minor, as defined at I&N Section 11843A. Mr. Garcia, through smart counsel, petitioned for review, who must have been simply devastated when, a year later, the Second Circuit held that literally this exact statute is an aggravated felony crime of child abuse in Dec v. Garland, episode 144. Honestly, then, the fact that counsel succeeded in getting another published decision on this exact same statute is a very small win in and of itself. Mr. Garcia argues here that the Beck doesn't bind because the decision failed to analyze whether there exists a minimum age differential between the victim and perpetrator. Plus, he argues the Beck was based on Chevron deference, which is no more because of loaf of bread. The Second Circuit gave it quite a lot of analysis, but rejected the arguments. The categorical approach applies, of course, meaning we need to know the elements of the offense and the removal provision. Under New York law, a person is guilty of second-degree sexual abuse. Quote, 1, when he or she subjects another person to sexual contact, and 2, when such person is less than 14 years old, end quote. Section 130.003 of New York penal law defines, quote, sexual contact, end quote, as, quote, any touching of the sexual or other intimate parts of a person for the purpose of gratifying sexual desire of either party, end quote. And again, the Second Circuit already held in Dec that this matches the ag-fel definition. Dec also apparently rejected an Esquivel-Quintana type argument about the victim age differential, according to the Second Circuit here. Mr. Garcia nevertheless argues that the statute can't be an aggravated felony because it covers a mere kiss on the lips, whereas federal law requires something more. And also that the New York law requires no age differential between perpetrator and victim, whereas federal aggravated felony law does. But first again, the Second Circuit doesn't believe it can avoid Dec, which is directly on point with this statute. And in any event, it rejects Mr. Garcia's premises. The court doesn't believe that a mere kiss on the mouth can result in conviction. Anything it might have said otherwise in the past was mere dicta. The statute requires contact with intimate body parts, explains the court. As to the age differential thing, well, the Second Circuit believes Dec actually got to that in a footnote and that Mr. Garcia is misunderstanding that footnote. The victim must be 14 for this New York crime, and, quote, for victims that young, the New York statute did not need to require an age differential, end quote, to make it an aggravated felony. On to Chevron and Loper Bright then. Well, strap in if you're not already strapped. The Second Circuit rejected the argument. First, certainly channeling LeBron and his decision to shirk the Knicks for the Miami Heat, go Heat. The court notes that it would essentially be relying on Loper Bright, quote, to disregard not 1, not 2, not 3, but at least 4 binding precedents of this court, end quote. Indeed. Before, quote, triggering such an upheaval, end quote, the Second Circuit paused. And it wrapped itself in the warm blanket of the Supreme Court's frustrating sentence from Loper Bright, where the Supreme Court stated that it will, quote, not call into question prior cases that relied on the Chevron framework. The holdings from those cases that specific agency actions are lawful are still subject to statutory stare decisis despite our change in interpretive methodology, end quote. A sentence that I truly believe is best read to apply only to Supreme Court precedent, but I am clearly wrong. Mr. Garcia's attorneys made that same argument. Maybe they're podcast listeners. Hit me up. But explain the Second Circuit, quote, the Supreme Court in Loper Bright made no such distinction, and we are wary of drawing one ourselves, end quote. Indeed. And indeed, quote, one might even argue that the Supreme Court's ability to set us straight argues in favor of a stronger version of stare decisis among the inferior courts, end quote. It's complicated stuff, but suffice it to say the Second Circuit is ripping out my heart. In any event, explained the court, Dec doesn't really rely on Chevron deference anyway. And heck, the panel agrees with Dec. Many smart arguments rejected. Now, the IJ and the BIA had also denied Mr. Garcia's withholding of removal and CAT claim, including an argument that under matter of BZR, the conviction shouldn't weigh heavily on a particularly serious crime analysis given Mr. Garcia's apparent mental health issues. He moved to reopen that portion while his petition for review was, well, on petition, and the BIA denied it. The Second Circuit affirmed that too. That came down to an equitable tolling discussion, as the motion to reopen was untimely, and the Second Circuit held that its review of that primarily fact-based inquiry was deferential. A ruling similar to what all the courts are doing post-Wilkinson, creating subclasses of mixed questions of law and fact. Justice Sotomayor. Though such review has long been, quote, highly deferential, end quote, in the Second Circuit, apparently. Now, Mr. Garcia argued, quote, that his motion merited equitable tolling because he had only recently become aware of the purported connection between his type 2 diabetes and his offensive conduct. Specifically, Mr. Garcia argues that the diabetes might have impacted his ability to understand what he was doing at the time he improperly touched the you-know-what of the 7-year-old victim in his sex abuse case, end quote. But the mental health and the diabetes stuff all existed at the time of the proceedings below, explains the Second Circuit. So it didn't really see a case for equitable tolling. and Mr. Garcia remains ordered removed. Some final thoughts. This decision is a lot. You know that because it's one of those ones that has a bulleted summary at the end of what the Second Circuit just held. There were a lot of smart arguments made in this case, and I do not have time to do all of them justice. One, for example, regards an argument to expand Nasrallah's review of fact-finding in the CAT context to the withholding of removal context, which is totally a correct argument, especially in light of Riley, in my humble opinion. Peek footnote 5. And read this decision if you want to learn a lot of things. And that is Garcia Pinach v. Bondi. Final case before the break is Wassily v. Bondi and Velasquez Arreaga v. Bondi, published by the Second Circuit on August 7th, 2025. The Second Circuit had some very long decisions this week. This one is about two individuals presenting similar issues, whether non-citizens seeking adjustment to lawful permanent resident status under I&A Section 209B must maintain their current asylum status, or whether non-citizens may adjust even if their asylum status has been terminated. That old issue. It's the former. Judge Robinson dissented. Mr. Wassily is from Egypt and was granted asylum in 2000. But he lost that status following a conviction and was eventually ordered removed. The way that works is DHS moves to reopen the removal proceedings where asylum has been granted and moves to terminate asylum, and then the non-citizen applies for other relief if the IJ terminates asylum. At least that's what happened here. Until that is, Mr. Wassily moved the BIA to remand, arguing his first attorney was ineffective for failing to apply for adjustment of status under I&A Section 209B. The BIA granted that motion, and on remand the IJ again terminated asylum, finding that the conviction was a particularly serious crime, but granted adjustment of status afterwards. DHS appealed, and during that appeal, the BIA published matter of TCA, episode 96, which holds that an IJ can't do that. Once asylum is terminated, the former asylee becomes ineligible to adjust under 209. The Fourth Circuit affirmed TCA on direct petition for review. Clea v. Garland, episode 170. I guess the C stands for Clea. And with matter of TCA binding, the BIA took away Mr. Wassily's adjustment of status grant. Similar thing with Mr. Velasquez Arreaga, albeit an asylum grant from 1996 that he waited way too long to adjust through, meaning it got terminated in 2018 following a criminal history. And in his case, an IJ didn't even grant adjustment of status, believing adjustment unavailable. Matter of TCA aside, the Second Circuit here believes the plain text of I&A Section 209 precludes adjustment of status for both individuals under these circumstances. Because here's the thing, explains the court. Once, quote, granted asylum, end quote, for individuals to adjust under the special asylee adjustment provision, and barring exceptions not applicable here, the non-citizen must, quote, have been physically present to the U.S. for at least 1 year after being granted asylum, continue to be a refugee within the meaning of the I&A, not be firmly resettled in any foreign country, and be admissible, end quote. Seems difficult for the non-citizens here then, right? But to the court, it actually turns on another provision. The full clause reads that, quote, the status of any non-citizen granted asylum, end quote, can adjust. The Second Circuit agreed with the Fourth Circuit that, quote, the ordinary meaning of status signals a present condition, end quote. Restated, while the statute does say it applies to non-citizens, quote, granted asylum, end quote, that doesn't simply mean a grant at any point in the past, regardless of what happens later. Quote, in fact, if Congress intended to permit anyone previously granted asylum to become a lawful permanent resident, as the dissent suggests, there would be no need for Congress to use the word status at all, end quote. Plus, other sections of Section 208 use the word granted to, quote, refer to then existing asylum status, end quote. At base, the Second Circuit majority believes that a contrary interpretation would make the I&A's framework for termination of asylum irrelevant, and that the position doesn't make sense. Although in a footnote, the Second Circuit notes, rather tersely, that its holding here conflicts with of all circuits, the Fifth Circuit's in Sui v. Holder from 2014. In that case, the Fifth Circuit held that a non-citizen, quote, whose asylum has been terminated is not prohibited from applying for adjustment of status, end quote. That makes this, you guessed it, a circuit split. Tangling with the dissent for a bit and rejecting some other arguments, the majority dismissed the petitions for review. Judge Robinson dissented, believing the issue difficult, but would in large part side with the Fifth Circuit over the Fourth Circuit. And that is Wassily v. Bondi and Velasquez Arreaga v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Welcome back to Fiddler v. Bondi, published by the 7th Circuit on August 7th, 2025. Couldn't help it. Sorry, not sorry. This case is about Convention Against Torture Protection. Mr. Fiddler is from Jamaica. He was admitted, seemingly as a lawful permanent resident, in 1988 at 10 years old, and he has suffered from mental illness since he was a child, including schizophrenia. He killed someone in 1998 and spent 28 years in prison. Then, DHS sought to remove him. His CAT claim is based on how he asserts that those mental illnesses are likely to be treated in Jamaica, the harm he's going to suffer because of it. An expert testified in immigration court in support, in addition to the submission of substantial evidence. For example, statistics show that, quote, there were 55,000 mentally ill people in Jamaica out of 3 million total people, making up 1.8% of the population, but 19% of police shootings in 2020, end quote. Other evidence, too. The immigration judge in the BIA denied, albeit eventually with a split BIA, through a dissenting BIA member who has since been fired from the BIA. Unjustifiably so, if you ask me. The Seventh Circuit affirmed the BIA majority, which does constitute the final agency decision, dissent notwithstanding. Under BIA precedent, torture is extreme and must be intentional and for a prescribed purpose. Quote, rough and deplorable treatment such as police brutality does not amount to torture, end quote. Simply put, quote, that an applicant is returning to a dangerous country by itself does not permit him to make out a CAT claim, end quote. Mr. Fiddler took issue with the BIA's specific intent requirement. To the court, Mr. Fiddler was arguing that intent and purpose are two very different things. Quote, he believes that a police shooting, by the very nature of the act, satisfies the specific intent requirement because it inflicts severe pain, end quote, intentionally, of course. Can't argue with that. But the CAT does indeed require more, explains the Seventh Circuit. Torture must be specifically intended for one of the prescribed purpose examples, albeit incomplete regulatory examples, I believe. Such as, though, for example, to extract information or because of hatred of the person. It is for this reason, explains the Seventh Circuit, that the BIA keeps denying prison condition CAT cases. Quote, the purpose, or lack thereof, of poor detainment conditions informs the BIA's determination of whether there is sufficient evidence of intent, end quote. Here, to the Seventh Circuit, the court didn't see a record that police in Jamaica are using force against mentally ill people, quote, unnecessary to achieve a permissible purpose, end quote. That's an interesting standard, though, one I think I can work with in some cases. Nor does the court see a record where the Jamaican government or its representatives are willfully blind to the harms committed by private individuals. Investigations and prosecutions did occur in Jamaica, if not always so quick, explains the court. And it doesn't seem like there are that many specific examples of private actor violence in the record anyway, which is quite a difficult thing to prove through country condition reports. Quote, without evidence indicating government acquiescence to the violence, reports of widespread crime do not amount to torture, end quote. I could be wrong, but I didn't see mention of what that expert testified to in the Seventh Circuit's analysis. There's little good for non-citizens in this decision, except for a citation, one of the first in my memory, to Professor Ankur and Jeffrey Chase's 2024 Asylum Law Treatise. But Mr. Fiddler lost his case. And that is Fiddler v. Bondi. Moving on to Cortez et al. V. Bondi, published by the 10th Circuit on August 5th, 2025. There are two from the 10th Circuit this week. This case is about notices of appeal. Miss Cortez and her minor son are from El Salvador. They applied for asylum and related relief and protection in removal proceedings and were denied. They appealed to the BIA through counsel. As we all know, that notice of appeal must be filed within 30 days. Counsel submitted the notice of appeal electronically through ECAS, the electronic BIA filing system, where, as here, electronic service is permitted, DHS is automatically served with the filing, as are we when DHS files something. Counsel signed the notice of appeal, but did not sign the process of service section swearing that DHS had been served. One of the reasons that counsel didn't do this is because the form instructions state, quote, complete, and if applicable, sign the proof of service to show you did this, end quote. Then in the proof of service section below another signature line, the attorney checked a box indicating, quote, no service needed. I electronically filed this document and the opposing party is participating in ECAS, end quote. The attorney left blank the signature line of the box. Anyone who's filed an E26 or some of these other forms in ECAS knows what this looks like, but the 10th Circuit provides a very helpful image in its decision. The 10th Circuit is feeling imagey this week. Looking at that image, the best reading of the form, to me, has always been that proof of service and signature isn't needed if you check the final box affirming that no service is needed because it's ECAS. But then again, the section is titled, quote, proof of service, you must complete this, end quote. But then again, that no service needed box is in that section. Better forms have been created. I think I personally always fill out the proof of service and check the box and sign, But now that I think about it, I think if you check the box, the form might delete what you had inputted previously. Can't recall offhand, but I feel like that's happened to me. As you can imagine, because we're doing this absurd issue, the BIA rejected the filing and thereby dismissed the appeal, subjecting this family to removal no matter how wrong the IJ's decision might have been. But it was the BIA who was wrong, explains the 10th Circuit. I wanted to get in that zinger, so I skipped this. In fairness to the BIA, they gave the family 15 days to cure the rejected filing. Why the attorney didn't cure it is beyond me and, quite frankly, a bit reckless, although maybe it was missed. Seems like something fell through the cracks based on the procedural scramble that happened afterwards that I am not going to get into, but it is chaos. It did not ultimately matter, though, to the 10th Circuit. And this issue was ultimately adjudicated in the context of a motion to reconsider. No signature is required on a notice of appeal, and presumably other forms with identical certificate of service portions when done through ECAS, and the ECAS box is checked in the 10th Circuit. And be careful with that, though. But to the 10th Circuit, heck, the form instructions state, quote, electronic filers are not required to serve the opposing party if the opposing party is participating in ECAS. EOIR's ECAS system will provide an electronic service notification to participating parties, end quote. The regulations state similarly. And there's that whole box issue that I discussed before. And that language that I discussed before as well, that is quite confusing. Quote, the government admits that, if applicable sentence, injects a degree of ambiguity into the process. But that is an understatement. The form clearly implies that there are situations where signing the proof of service is inapplicable, and the obvious situation is where it is unnecessary to show you did this, serve the opposing party, because you filed electronically, end quote. The 10th Circuit believes the instructions, quote, inartful, end quote, and that Ms. Cortez and her counsel did not violate them. Seems that the BIA has since revised the form and now, quote, places the signature line below the checkbox, which better suggests that a signature is required even if the box is checked, end quote. So that indicates to the court that it was quite unclear before at a minimum. Nothing in the BIA's rules or regulations requires the 10th Circuit to reject, quote, the most reasonable interpretation of the form's instructions, end quote. Indeed, the BIA practice manual only requires signature by the person servicing, and here to the court, no one is serving. ECAS is serving. The nameless, faceless immigration robot who I shall henceforth refer to elegantly as ECASius. Rejecting Oil's other arguments, the 10th Circuit vacated and remanded. Meaning congratulations, Mark Robert Barr, for petitioner, who might have only came in at the petition for review stage, I do not know, but congratulations, what a nightmare. An observation. I don't know, guys. If for no other reason than to cover my own matter of butt, be wary of this decision. Rules and forms change, and it seems that the notice of appeal form might now be different than the version that the 10th Circuit was adjudicating. And who wants to fight this fight? If the form allows, check the box and additionally fill out the certificate of service and sign. Paranoia gets you quite far in immigration. And that is Cortez et al. V. Bondi. Coming to Chavez-Govia v. Bondi, published by the 10th Circuit on August 5, 2025. Quote, this petition involves immigration proceedings, end quote. You don't say. It's actually about filing deadlines. Mr. Chavez-Govia is from Mexico. In removal proceedings, an immigration judge gave him 15 days to fill out and submit a Form I-589 to apply for asylum. He was also advised of his right to an attorney and provided a list of legal representatives who could rep him for free or at a reduced rate, as always occurs. Maybe at the next hearing, but I actually think it was at that first hearing. Quote, Mr. Chavez-Govia said that he would represent himself and wanted only to consult a deportation officer about leaving the country voluntarily, end quote. Probably because he was detained, if I had to guess. But he changed his mind at the next hearing, apparently 15 or more days later. He requested a continuance. The immigration judge inquired into his asylum claim and then denied everything. Mr. Chavez-Govilla appealed to the BIA, and the BIA affirmed. To the 10th Circuit it came, and the 10th Circuit reviews all of this for abuse of discretion. Quote, in applying this standard, we consider the parties' arguments involving the complexity of the form, the available help for Mr. Chavez-Govilla, and his attentiveness. End quote. First, the 10th Circuit was unswayed by the fact that Mr. Chavez-Govilla only speaks Spanish because there was a translator in court, everything was explained to him, and he received pertinent forms in Spanish. Given this, the 10th Circuit saw the 15 days provided by the immigration judge to file the asylum application reasonable. Well, what about the denial of the continuance? Well, here, Mr. Chavez-Govilla seemed to have tanked himself by being honest in court. When at that next hearing the IJ asked him why he needed more time, he responded that he hadn't, quote, really paid that much attention, end quote, at the earlier hearing. No tribunal seems interested in that excuse. And in any event, the IJ then explored the relief eligibility a bit, explains the 10th Circuit. The court also didn't believe that all this amounted to a deprivation of his right to counsel. Mr. Chavez-Govilla was advised of his rights, and to the court he said he understood and said he wanted to represent himself. Finally, the 10th Circuit didn't see a due process violation. The IJ sufficiently developed the record to the court, and Mr. Chavez-Govilla did not act with diligence, having muffed that first hearing and 15 days later to the court. Quote, regardless of Mr. Chavez-Govilla's reason, his inattention reflected a lack of diligence. End quote. The IJ inquired briefly, but enough to the court, about Mr. Chavez-Govilla's apparent fears of the Zetas cartel, which admittingly, as reflected in this decision, is a bit confused. Seems that Mr. Chavez-Govilla later filed a motion to reopen, but the 10th Circuit sees nothing wrong with the BIA's denial of that too. It includes a flowchart and everything in its decision, and that's because for some reason the 10th Circuit granted another petition in the interim for Mr. Chavez-Govilla, which made the BIA's first decision not final, meaning there was nothing for the BIA to reopen. That is, once it was remanded from the 10th Circuit. Interesting. And thank you for the flowchart. Nor did the BIA have an obligation under these circumstances to treat the motion to reopen, which was then procedurally unnecessary, like a motion to remand, even though 8 CFR section 1003.2c4 does permit it to do so under some circumstances. The 10th Circuit therefore denied the petition for review. Strange, wonky case. And that is Chavez-Govilla v. Bondi. We conclude with Lopez Martinez v. Bondi, published by the 11th Circuit on August 6, 2025. This case is about exceptional and extremely unusual hardship. First time I've seen Judge Abudu on an immigration panel, I think, but I could be wrong. The Supreme Court's Wilkinson decision, of course, permits review of this issue by the circuits now, but it's a deferential review, explains the 11th Circuit, and all circuits to have addressed the issue so far. Enter the petitioners, Isaac and Martha, a married couple from Mexico who have lived in the U.S. a long time. They, quote, have 2 U.S.-born and thus U.S. citizen minor children, end quote. I wonder which judge insisted on that parenthesis in the opinion. Truly, I'm not trying to infer it was necessarily Judge Abudu. One of the children has a learning disability and has been diagnosed with ADHD and takes specialized classes and seems to have quite a many educational needs. An immigration judge denied the relief, finding the hardship alleged just was not bad enough to the child. Child's acronym name being IL. The BIA affirmed. As did the 11th Circuit. The court spends a lot of time explaining which deferential standard of review it's going to pick post-Wilkinson, which I will spare you all, but it lands on the well-worn substantial evidence review. Seems like most circuits are doing that, although at least one has picked the ever so slightly better for non-citizens clear error review standard. And, quote, under the substantial evidence standard, a reviewing court asks whether on the record as a whole there is substantial evidence to support the agency's findings, end quote. Deferential to the BIA. Now, I did tell you I'd spare you the rationale, but this quote certainly struck me. Quote, despite their court-like trappings, immigration proceedings don't qualify as formal adjudications, end quote. Tell that to the non-citizens. That phrase, formal adjudication, is actually a legal term, and the whole thing is wonky, but the sentence remains. The missed opportunity to make immigration courts Article 1 during the Biden administration is really hitting hard right now, isn't it, everybody? Really should have focused on that one if it was at all possible to get through Congress, even though it was not a sexy issue. Anyway, applied to cancellation. The 11th Circuit and most courts now will, quote, review for substantial evidence the question whether the found facts in the administrative record, which again, we lack jurisdiction to second guess, add up to an exceptional and extremely unusual hardship, end quote. Honestly, this decision is a must-read going forward for understanding the various standards of review in all contexts in the 11th Circuit. Mark it down, 11th Circuit practitioners. Quote, on then at last to the merits, end quote. Only 4 of the 23 pages of this decision about the merits. Because after all, the review of the BIA's denial of relief in this context is quite deferential. The BIA believed that the child, IL, could obtain ADHD medications in Mexico, and that while schooling options might be, quote, fewer, end quote, the child wouldn't be, quote, entirely deprived of all schooling, end quote. That's truly turning into the very high standard in these cases, but hey, it's a standard. The 11th Circuit believed these conclusions appropriate and supported by the record, particularly as the court doesn't believe it can reweigh evidence. True, the BIA can't require a showing that medications are completely unavailable in a foreign country, but despite the BIA saying just that a few times in its decision, the 11th Circuit believes as a whole the BIA was applying the correct standard. That is, requiring a showing instead that the needed medications aren't, quote, reasonably available, end quote. It all means that Isaac and Martha, who are by all accounts good people, will likely be getting removed. Cancellation cases are just the toughest sometimes. Here's this before we go. Look at the 11th Circuit tempting me ever so slightly in a footnote, quote, no party argued that we should apply a different standard in light of Loper Bright, and so we don't reach the issue here, end quote. That is, a different hardship standard from what the BIA has been applying for 24 years, where medical hardship to a child is alleged. Open issue in the 11th Circuit, everyone. That is, whether the 11th Circuit might go back and redefine what kind of hardship is required from what the BIA has been saying for 2.5 decades. Don't hold your breath, but it's open. And that is Lopez Martinez v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Wassily & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.